We might get started, and my apologies again for everyone who braved the weather and arrived in person. For those who are listening online, as mentioned in the chat, we're going to commence a little bit earlier than advertised, and apologies again for the miscommunication and the crossing of wires. We are still going to aim to wrap up in an hour or so, and I think Andrew is broadly agreeable to that. So Andrew and I have been chatting, and we thought this seminar would be most valuable and most enjoyable if we can engage in a more kind of conversational style. And Andrew's very open to receiving questions from the floor as he's talking, but also via the chat. So I'll be manning the Q&A function, so if you do have questions and you are listening online, please send in your questions via the Q&A, and I will attempt to get Andrew's attention and raise those questions on your behalf. So Professor Andrew Stewart needs little introduction for most of us in the labour law world, but for those who are less familiar with Andrew, he is a John Bray Professor of Law at the University of Adelaide, an adjunct professor with QUT's Centre for Decent Work and Industry. He's also a consultant with the national law firm Piper Alderman. He is lead author on Crichton and Stewart and Stewart's Guide to Employment Law. Again, most of us are fairly familiar with those textbooks. So it's our pleasure for the Centre for Employment and Labour Relations Law. I'm the director of that centre. My name is Tess Hardy, again, for those who don't know me, and I'm very pleased to welcome you to the seminar. So over to you, Andrew.
All right, thanks very much, Tess, and good evening, everyone, both in the room and listening online. It is a pleasure with all due respect to those of you connecting virtually. It is a great pleasure to actually be sitting in a room talking to actual faces. And again, can I encourage those of you in the room and online to ask questions as we go. I may not have the answers, but I'll do my very best. The topic I've got tonight is talking about insecure work and what the Albanese government is doing about it. When the Labor Party won the federal election nearly 12 months ago, their election platform was very, very heavily skewed to two topics or concerns in particular. One of them was gender equality. The other was insecure work. There turned out to be, because of the way the campaign developed, a bit about wages as well. But the concerns coming into government, the plans coming into government around industrial legislation, very much focused on those two topics. And so I'm going to talk about one of those tonight, although with some pretty clear overlaps to issues of gender equality as well. All right, so 4 questions. What is insecure work? That's the easy one. No, just kidding. What has the Albanese government done about it so far? And the answer is a little bit on one topic in particular. What is it planning to do? An awful lot on some pretty major areas. And what isn't it doing, or at least what hasn't it yet clearly signalled that it's going to do? So what might be the missing elements in the government's agenda? So let's start with what is insecure work. There are a lot of different dimensions to the concept of insecurity, literature about this. Okay, so when most people hear the phrase employment security or insecure work, they're actually thinking about job insecurity. The idea that you don't know whether you have a job or not, you don't know how long your job is going to last. But there are clearly other dimensions of security that overlap with security around your job. So security about income. How confident are you that your income is going to be sufficient, that it's going to fluctuate, that it's going to be below the levels that you really want or need it to be? Security of hours is a significant issue for many part-time and casual workers, and I'll certainly be talking about that tonight. And then there are at least 2 other dimensions that I'm just going to note here and say these are really, really important, but purely for reasons of time, I'm not going to talk about tonight. Security of residence, which is such a significant issue at the moment in two completely different ways. Housing crisis that we increasingly have in Australia, and which clearly can overlap with issues of insecure work if you cannot earn the income necessary to pay the exorbitant rents that are now being charged in many, many parts of Australia. That is clearly an important policy issue. But then security of residence for migrant workers, the idea that you are here in Australia on a temporary visa where your ability to remain in the country is tied potentially to the job that you're currently doing. That's another very significant issue. Of course, we've heard some recent announcements about that from the government in terms of potential reforms to Australia's labour migration system. Again, I'm going to put that to one side, not because it's not important, but purely for reasons of time. And then finally, security at the level of personal safety is clearly something to think about in any number of different ways that range from what might be conditions of slavery in one instance to doing physically dangerous work or mentally dangerous work. So having said, yes, there are an awful lot of dimensions here, primarily talking about job security, but with some attention to income security and security of hours as well. So is work becoming less secure? There's an awful lot of claims that that is the case. Are those claims correct? Depends who you believe, depends which figures you look at. The Senate Select Committee on Job Security that issued its final report in February 2022 had no doubt whatsoever that there was a story to be told about work becoming less secure and quoted a lot of data to support that. There is a rebuttal to many of those arguments presented in that report and other sources in a paper that Mark Wooden from the Melbourne Institute put out last year. My own view is that I tend to side with Mark's arguments to a great extent. I think that the story about an increase in insecure work is difficult to maintain in light of the actual data, the data both about types of work and about subjective perceptions about job security. If you want to look at the latest figures on types of work, the statistical report, which is updated every couple of weeks, that's prepared for the Fair Work Commission for its annual wage review, has got this year, I'm not sure if they've done this before, I suspect this is new, they've now got a section on insecure work and they've got a good summary of some of the current ABS data about various types of insecure work, updated to reflect the most recent figures about hours of work. But overall, I think on balance, my view is that claims about work becoming less secure are in many instances exaggerated. But, and it's a big but, even if that's right, that is not to say that we don't have huge problems with insecure work. So even if you can run the argument that in many respects, jobs are not noticeably less secure than they were 20 years ago, there's still an awful lot that's wrong about our labour market. There are too many permanent, ongoing jobs which are designated as casual. I'll come back to that, obviously, as one of the big issues for government reform. Permanent part-time employment is arguably either too flexible or it's not flexible enough. Ian Campbell, who's with us tonight, and Sarah Charlesworth done some terrific work identifying ways in which so-called permanent part-time employment can be used to create enormous insecurity through contracts that have a low floor of guaranteed hours and then huge flexibility above, often to have extra work done without incurring overtime rates of pay. I think that is a serious issue in some sectors. But equally, I'd say there are other sectors where permanent part-time employment is sufficiently inflexible that it drives employers and workers into casual engagements. I'll come back to that point a little later as being part of the possible solution to issues of casual employment. Fixed-term employment, not at all clear that the ABS data are correct on fixed-term employment. The ABS persistently claims that fixed-term employment is between 3 and 4% of the workforce. There was some very good work done nearly 20 years ago now in both the Productivity Commission and by Anthony O'Donnell, which cast doubt on those figures. I haven't been able to find any recent work that replicates some of that analysis, but I think there is reason to believe that particularly if you define fixed-term employment more broadly, as the new legislation does, I'll come to that shortly, I think there's a very good argument to say that it's a bigger part of the labour market than 3 to 4%. But in any event, I don't think there's any doubt that when you look at some of the areas in which rolling fixed-term contracts are used, it simply isn't an objective justification for having that arrangement. Labour hire. Labour hire is, I've always had the view that that there's room for labour hire in a modern labour market, but it can be used in ways which create huge issues. Any number of reports showing that in industries like horticulture, meat processing and so on, that can be used to facilitate wage theft, in particular with fly-by-night agencies where your employer is somebody with a mobile phone and, you know, if problems emerge, all of a sudden the phone doesn't answer. It can be used to undercut negotiated conditions. I'll come back to that when we talk about same job, same pay. And of course, under the ODCO system, labour hire can be used to avoid employment as well. And I know that the High Court's decision last year in the personnel contracting case certainly was a blow against the ODCO system, where the Mr. McCourt, the enthusiastic backpacker, was found to be an employee when sent to work on a building site by his agency. But the fact is, the tenor of the High Court decision, and this is certainly a point I'm going to return to, the tenor of that High Court decision is such that the contract, Mr. McCourt's contract, would be one that could be very, very easily rewritten to ensure that he was in fact the independent contractor that his agency intended him to be. So there are issues with labour hire. Digital platform work, something I've spoken a lot about in recent years. I'm not going to say too much about that other than to note that there's every reason to think that it continues to be on the rise. The big national survey, which I helped run a few years ago for the Victorian government, showed a surprisingly large number of people engaging in platform work, though only a pretty small number relying on it for their full income. But there's an awful lot of evidence to suggest that platform work is on the rise in certain sectors, and I would single out the care sectors in particular, and looking forward to some research which I gather is going to be published fairly soon from the Centre for Future Work, Fiona McDonald and her colleagues, which will help shed light on some of those issues. Again, there's been a lot said and written about so-called fissured employment or indirect employment, the idea that you run a business but you don't hire the staff that you need, you subcontract, you outsource, you franchise, you find ways of having someone other than a direct employee undertaking work for you. What that trend has done has been to turn even permanent jobs into insecure jobs. If you're working for a firm that is reliant on a contract, you may feel that your job is fairly secure. You may hope that if your employer loses the contract, You'll get a job with the next contractor, but you might not. And you particularly won't if whichever the business was that was outsourcing wants to ensure that there isn't a transfer of business to the next contractor. They may very well make sure that there's no flow on of employees from one contractor to the other. And if there's reason to believe that insecure work might be on the increase, every shred of intuition I have tells me that if something is not done about the High Court's rulings on how employment is defined, that there is going to be an explosion in the number of independent contractors. And they are not going to be genuine independent contractors. These are going to be sham contractors in the broad sense. That is, people who are in substance and reality employed, but legally are treated as independent contractors. Why? Because their contract says that they're independent contractors. Again, I'll come back to that.
Sorry, Andrew, you're saying that there has been a large growth overall in insecure work.
Yep.
In those categories there. Yep. Where has the largest growth been?
Okay, so we know that, so quick rundown of the figures. Casual employment over the last 20 years has fluctuated between 22 and 28% of employees. At the moment, it's sitting somewhere in the middle at 24, I think, at the moment. Certainly not as high as it has been. Contractors in their main job, static at around 8% of the workforce, again, over the last 20 to 30 years. Big increases in both those two categories in the 1990s, not so much since then. No measurable increase in, by the ABS anyway, in fixed term employment. Of course, the other point which I should have made is the other thing that makes reading any figures right now really hard is the pandemic, because there've been such ups and downs in various types of engagement over the last 3 to 4 years. Some evidence of an increase in multiple job holding. Platform work is hard because before 2019, we really just didn't have any data to measure that. But the sense is that that's on the increase. And yeah, the last point about sham contracting, I expect that if nothing is done about the High Court decisions, that we will gradually see that 8% go up to 10, 12, or the 15%, which you find in some other countries with weak definitions of employment, which we currently have. Okay, so what are Labor going to do about this? Here's a useful summary I found in a tweet from Anthony Albanese back in 2021, but this actually does capture exactly what Labor's 2022 policy is. And I'll be coming back to a couple of things on this list, but particularly the last two. But for the most part, that captures what they've sought to do so far in government. So let's have a look at what they're actually doing. So the first step is obviously the Secure Jobs Pay Act, really misnamed because if you're actually saying, well, what is it really about? It's about gender equality and revitalising collective bargaining. There are only two elements in it, and it's a very big act. Only two elements in it about job security, making job security a general object or purpose of the legislation. And then the really significant element, which is the restrictions on so-called fixed term contracts. You're going to see lots of quotes or air quotes from me in talking about fixed term contracts, because in fact, the provisions are not about fixed term contracts. They're about fixed or contingent term contracts. It's a very big difference. Otherwise, though, really the elements of that legislation are predominantly about gender equality and bargaining. Let's move on to look at the fixed term contract reforms. So there's a prohibition which will come into force in December, 6th of December this year, on 3 types of arrangements. One, in each case, we're talking about An employment contract, so it doesn't affect contracts for services or independent contractor arrangements, so the employment contracts, with a term that provides the contract will terminate at the end of an identifiable period, not fixed, not specified, identifiable. I'll come back to what identifiable means in a minute. In 3 circumstances, if the period is more than 2 years, so that's the easy one, but then the other 2 are equally important. If the contract has an option to extend or renew the period more than once, or for a total period that exceeds 2 years, or then the third one, if the employee is engaged under more than 2 such contracts, or under successive contracts for a total of more than 2 years. So you can't have 3 3-month contracts. You can't have a contract that can be renewed 3 times, regardless of the total length. Those are now prohibited. So what does identifiable period means? So when you see a phrase pop up in legislation that you think, okay, the first thing I need to do is look for a definition. There is none. Then I need to look in the explanatory memorandum to see what the explanation is. There isn't one. In fact, the explanatory memorandum does use the phrase identifiable period, I think 8 times in total, none of them in relation to this part of the legislation. So the explanatory memorandum ignores the phrase. So what does it mean? By inference, and if we believe a note that technically relates to only one section, one subsection, but arguably applies to others, it actually means either a contract for a specified period, like 3 years, or a contract for a specified task, that is until a project is completed or until funding runs out, or for a season, a period of time that could differ from year to year, but is essentially measured by the state of the climate or the state of a crop, whatever it might be. So this isn't just applying to fixed terms. Now, there's a puzzle here, there's a drafting puzzle. I honestly don't know what the answer is. I mean, one answer is that somebody started drafting it thinking we're talking about fixed terms, and then someone else asked, so what's that mean? Hang on. So if we say it's only for a specified period, it's easy to get round because you just simply say, well, it's not for a specified period, it's for as long as we have funding or for as long as this project is alive. And so then it's redrafted, but everyone somehow forgets to explain this. I don't know. It's a mystery. They were working very fast. I think that's probably the explanation. But in my view, it is clear that identifiable period does not mean a specified period. It means a specified period or a specified task or a specified season or any arrangement in which the period is capable of being identified by reference to some form of criteria, some criteria, objective criteria of some description. All right, the legislation does say quite clearly that it's irrelevant that the contract can be terminated before the period ends. So even if your contract can be terminated by notice at any time, that doesn't stop it being for a contract for an identifiable period. So it covers what are often called maximum term or outer limits contracts. Casual contracts are excluded. So if you have a casual contract, none of these rules apply. The reason I've said on the slide for now is that when it comes to drafting the new provisions about the definition of casual employment, I'm hoping that the government will address the question I've persistently been asking since the Morrison government introduced its new definition of casual employment in 2021, which is, where's the borderline between casual employment and fixed term employment? Again, I'll come back to that point. But I think there's some possibility that in figuring out what a casual contract is or isn't, there's some possibility that there might be some re-examination. The short version of that concern is this: everyone agrees that if you get a job for the duration of the Grand Prix or the Royal Show or some really, or the Writers' Festival, some short-term event, that is a casual contract, even though you have a contract for a definite period of time and you're guaranteed work and you're required to show up for the entirety of the period. Everyone assumes that a really, really short-term contract can be a casual contract. Everyone is equally agreed that like a 3-year contract can't be a casual contract. And so my awkward, annoying question is, all right, so where's the borderline? At what point? If you're hired to work for 4 months for the duration of a university semester, working as a casual tutor, why are you a casual rather than a fixed term employee? Right? I can't find a sensible way of answering that question. And I'm hoping at some point the legislation will be drafted in such a way that there is an answer. What else? The legislation makes it clear that breaks between contracts are disregarded where there is substantial continuity. So if you're hired for the duration of school year and then get another contract from the start of the following school year, those contracts will be treated as running successively, even though there's potentially a month, couple of months break in between. One interesting feature of the legislation is that if you have a contract that falls within the prohibition, it's automatically treated as not having the identifiable period in it. So in other words, it's a continuing contract. Now, the legislation doesn't actually say what then happens, because of course, logically, if you take out the identifiable period, but there is no provision for notice of termination, what you then have is a contract of slavery, because you now have lifelong employment. Surely the answer is, this is the answer any lawyer would give, we just imply a term in that case, that it's termination on reasonable notice. That's the obvious answer, not totally clear to me why the legislation doesn't say that, but presumably that's the answer. And then there's a prohibition on avoiding these limits by just churning through a succession of employees. So how effective that will be and how easy it might be to prove intent. Oh, no, we didn't let them go to avoid the limit. We just didn't think they were very good. But as with all anti-avoidance mechanisms, the issues of proof are always going to be significant. Questions?
Thank you. I've got a question from the online audience. This one comes from Bray Booth, and she asks, do you think these rules are flexible enough to account for areas where funding is genuinely precarious and an employer might not be able to guarantee the presence of funding to support an ongoing position? She gives the example of community legal centres.
Yeah. Can I park that question very briefly until I've done the next slide, but I will definitely come back to it. So what is absolutely key here, having understood the prohibitions, is the long list of exceptions. But these exceptions are clearly not long enough to deal with many common situations, of which that's one. So for a start, where you have a contract for a distinct and identifiable task involving specialised skills, I'm really confident that that exception is going to be misinterpreted to mean if you're a highly skilled employee. No, you have to be a skilled employee called on to work on a task. So having somebody who's good at IT is not within this exception. Having somebody who's good at IT to work on rolling out a particular software project that could take anywhere from 6 months to 12 years. I might be exaggerating slightly. That would be potentially within it. Accommodating essential work during an emergency, a period of peak demand, or another employee's temporary absence. So a classic example there is the mat leave replacement for somebody who ends up having at least 2 or potentially more than 2 children successively, so that what was initially expected to be a 6 to 12 month absence turns into a 2 to 3 year absence. So somebody who's rolled over with successive contracts while replacing somebody on mat leave would fall within that. That would be my view. Remuneration over the higher income threshold, or pro rata if you're part-time. So at the moment that's 166,000. That will obviously mean that many executive positions in businesses will be excluded. It will not exclude a huge number of non-profit organisations. Awful lot of non-profit organisations have very senior people earning less than the high income threshold. They're going to have to change their contracts. The position depends on a prescribed type of government funding for which there is no reasonable prospect of renewal. Right, now we come to that question about it's no reasonable prospect of renewal. Very, very often when you look at the situation of many organisations, they actually have had government funding renewed many times. It's often fluctuated, but it can't be said there's no reasonable expectation of renewal. There's a fear of a lack of renewal. But on the face of it, those organisations, unless there is some new exception introduced to deal with that situation, or unless a court gives a very, very broad view, a broad interpretation of no reasonable prospect, that is really, I think, going to mean that in a lot of these organisations, they're going to have to switch to indefinite contracts, which in turn means a liability for redundancy pay, which becomes a further hit on their funding because that's going to have to be accounted for. So that would be an area where I think there's some chance we might see a new exception introduced.
I have a follow-up question, and it relates to university funding,
Yep.
of which I have an interest. And I guess there's a lot of university staff that are engaged on funding that is project-based. And I do wonder whether or not there is a reasonable prospect of renewal for some of these positions. What's your view?
The answer is that is not going to be the relevant question. The relevant question is 2 points on. An exception that's permitted by an award that covers an employee. So there are several awards which have provisions in them specifically allowing fixed term contract. Higher Education Award is one of them. The award governing primary and secondary education is another. Then there are some other examples, mostly applying to government enterprises or what used to be government enterprises. So the Australia Post Award, for example, has got one of these exceptions. So the university exceptions, which, if I'm remembering correctly, date back to a decision in, I want to say 1998, that I reckon Commissioner Smith gave. Those awards have quite broad exceptions in them. And even if you are an employee who's covered by an enterprise agreement, your enterprise agreement is irrelevant for this purpose, unless the enterprise agreement allows for a broader exception. So if you have an enterprise agreement which says universities can use fixed term contracts in only 2 situations, and the award says universities can use them in 4 situations, it's the 4 situations that matter. If the enterprise agreement gives a university power to do something that the award doesn't, then the enterprise agreement will, or sorry, if the enterprise agreement is narrower, then, let me get that right. Try that answer again, Andrew.
It's all straightforward though, Andrew.
Oh, it is completely straightforward, as you can hear. If the enterprise agreement has tighter restrictions than the award, the tighter restrictions apply. If the enterprise agreement is more permissive than the award, those parts of the enterprise agreement no longer apply. It's the award that matters. So this also opens up the scope for awards of any type to be varied. I mean, it's possible that we might see employers approaching the Fair Work Commission to vary awards to broaden the scope for fixed term employment. And we might see unions approaching the Commission to narrow them, particularly the education unions. So at the moment, the answer is most of the situations I'm aware of where fixed term contracts are used in higher education will be perfectly legal because they fall within the award. But I'm saying that as a generality and still necessary to go back to the wording of the award, and there may well be some situations where that's not true.
Thank you. One related question before we move on, and that's a question from our online audience, Hilary de Greenband, and she asked, do you think the funding exception is only meant to apply to grant style funded roles, or is there a chance it might apply where the roles are funded by government commercial contracts?
Well, the exception that's in the legislation is really narrow because it's not just for government funding, it's for a prescribed type of government funding. So there would have to be a regulation passed to say it's this type of government funding. So it's very difficult at the moment to know how broad that exception is. I'm just predicting that there will be pressure on the government from the not-for-profit sector to use the regulation power to broaden the exceptions. The other one where I'm really confident that we'll see this, at the moment, there's no exception for somebody who's brought into Australia under a temporary skill shortage visa. Now, those visas are invariably time limited, but they're usually more than 2 years. At the moment, you would have to give those employees an indefinite contract, even though the visa prohibits that. So there's a conundrum there, which I just would assume is going to be addressed by regulation. But I also think we'll see industries lobbying for their own regulations. The one that so annoyed that I didn't come up with this myself, somebody at an early session I did talking about the bill asked this question, it's a really good one. What about the AFL? What about professional sports? Now, of course, there are many AFL players who are paid over the high income threshold. But if you think about some of the rookie players or your lower tier players, fringe squad members, if they're earning below the high income threshold, none of the other exceptions apply. Unless you're going to say that the distinct and identifiable task is palming the ball in the ruck or, scurrying from dummy half for rugby league players. That's not going to apply, but I wonder if we will see professional sports agitating for their own exceptions so they can continue to use fixed term contracts, which are absolutely the norm. So it's really is a case of watch this space. So the last point to leave is the transitional one. It's an important one and it has its own set of really interesting issues. If there's a contract entered into before the new rules take effect, so that could include a contract entered in today, nothing to stop a 5-year contract being offered today, anytime up till 6 December, and that contract is immune unless the contract is subsequently extended or renewed, in which case, if it's extended or renewed, you count the period of the previous contract. So what that means is that you might give somebody a 3-year contract today, or they might be on a 3-year contract, but it cannot be renewed after 6th of December because you have exceeded the 2 years. So yeah, lots more to come, I think, before 6th of December rolls around on this, because there are so many questions. And I think we are going to see some action through regulations and maybe some action in the Commission around the award exceptions. So I'm just going to pause, see if there's any other questions people in the room about fixed terms.
Yeah, I've just got a question about your suggestion that there should be a potential expansion of the prescribed type of government funding for which no reasonable prospect of renewal.
Yeah.
For which no reasonable prospect of renewal. Isn't that quite a conscious kind of policy choice to make the threshold no reasonable prospect of renewal? And in fact, it is expressly directed to those circumstances like funding of legal services, community legal centres and other community services that that the threshold is no reasonable prospect of renewal, and in the circumstance where there is a history of funding, that employment should really be in the nature of ongoing employment, and the mere consequence of that really is not that an employer can't terminate somebody if there's a loss of funding, but that there is the consequential effect, as you've identified, that they may have to, in those circumstances, subject to any argument or ordinary and customary tenor of labour, to actually pay redundancy. And that's the consequential effect, and that's the conscious policy choice which is made.
Yeah, and just to be clear, so that's a really good question. Just to be clear, I'm not advocating for a broader exception. So what I'm saying is I'm expecting there will be pressure for a broader exception. I think there's a really good argument for what you say, that the fact that funding is precarious shouldn't necessarily mean that all that risk gets put onto employees. So I think I agree with you that's the case. I think there might be an argument to say that maybe that the existing way it's worded is a little too tight. But yeah, honestly, I think I'd want to reserve a view about that till I saw an alternative formulation. But yeah, I'm just predicting that there will be pressure from some not-for-profit groups to get a broader exception. All right, so there are 4 other matters which government is currently consulting about. The consultations are in advanced stage. They're due to finish, the consultations are due to finish in the next couple of weeks, and we expect to see legislation later this year. When? August, September, October, November, somewhere in that range. Do I think that all of these are going to be dealt with in the one act? Probably, but I think there's some possibility that some of these might be sufficiently difficult that they could be put off. Bearing in mind, this is a government that hasn't yet hit the 12-month mark and has already done a huge amount. They've still got plenty of time left in this term of government. But let's have a look at each of them. I'm going to try and deal with these fairly quickly given the time. So move to the next slide, please. So we start with casual employment. I suspect I really don't need to go over this too much because after all of the discussion around the work pack cases a couple of years ago and the Morrison government's 2021 legislation, it's fairly clear that we all understand that there's this tension between the fact that because historically awards and many enterprise agreements define casual employment as anyone who's engaged and paid as a casual, that there are a lot of people who are casuals purely because, not because of anything to do with their job being casual, but just purely because they were told that they were casual and paid as a casual, maybe. And then the tension with the understanding, which was around for a long time, well, really up until the High Court squashed the idea in August 2021 in the Workpac and Rosado case, but the idea that casual employment is something informal, uncertain and irregular. And you therefore had this potential problem of an employee being entitled to a casual loading because their award defines them, or their enterprise agreement defines them as a casual, but also entitled to the benefits for which the loading is meant to compensate because they're really not a casual at all. So the Morrison government sought to resolve that with a new definition that incorporates some of the language from the original federal court decisions in Skeen and Rosato. That is, a casual is somebody who accepts employment with no firm advance commitment to continuing an indefinite work according to an agreed pattern of work, but then the massive stings in the tail going on to say, just because you work the same number of hours every week doesn't mean to say that that means you do have an advance commitment. Oh, and your status is to be determined purely by what your contract says, not anything that happens after you are engaged. Then we also have the protection for workers who misclassify, who get even that wrong, so that if you are hit with a claim for unpaid annual leave, you can set off any casual loading that's been paid. And then the reliant on this, well, this is what solves the problem of ongoing casuals, the right for employees to elect to request or to be offered conversion to permanent employment after 12 months. Except, of course, the employer can refuse on reasonable grounds. And when they do, that's almost never challenged. I know there are some exceptions, but really not many. But more importantly, few casuals want conversion, because conversion, if your employer is observing the law, means an immediate pay cut to give you benefits which you may or may not use. And for many, many casuals, that is not a viable financial equation. I'm sceptical even of some of the data that says that even 25, 30, 40% of casuals want conversion, because my experience has been that you very often find casuals who really, really want conversion up until the point where they discover that they can't keep their casual loading. So I think that is a huge problem with the conversion mechanism. So again, we know there's a problem here. The stats make it quite clear here. The most recent ABS data, out of 2.7 million employees who are casual, which is one of the highest percentages of temporary employment in the world, an awful lot are doing ongoing jobs. So nearly a third have the same hours of work week to week. And of those, 500,000 in total have been employed for more than 12 months. And even the ones who've got irregular hours, more than 80% expect to be in the same job in 12 months' time. So it's well over 1 million employees, at any one time are designated as casuals in jobs which are ongoing. So what is Labor going to do about this? There's probably fewer indications on this issue than any of the others, because unlike the next three topics that I'm going to very, very quickly talk about, we haven't had any big discussion paper released. So there are some consultations going on over this issue. But what we can piece together from public sources is that Labor is committed to having an objective definition which takes account of what happens after a person is engaged as a casual, and they're committed to the idea that employees should have the choice to convert to casual employment, which is already the case. If you, though, really did apply a truly objective definition to those 1 million+ casual jobs which are actually ongoing, there would be huge pushback. And it would be pushback not just from employers, but from workers. So if you introduced a law which was fully implemented, you'd be telling more than 1 million mostly low-paid workers to take a pay cut, and you'd be infuriating a very, very large number of small businesses. So I don't think that's going to happen. What I would describe as the path of least resistance here, and what I would predict might happen from here, is that we have a new definition, which is based on pretty much on the Work Pact definition, the words already in section 15A, maybe with a reference to casual employment being temporary and irregular, minus the provisions that say you can't look at post-contract reality, you can't look at regularity of hours. And that will be sufficient to deal with the classic Work Pact type case. That is the mining worker who's sent off to work at a mine with a roster that's determined 12 months in advance. Couldn't be more regular. That type of worker will become a casual. The definition then will be capable of catching the really common situation in sectors like retail and hospitality, where you frequently start off with hours that fluctuate, but it then solidifies into a permanent job with either regular hours or hours that are irregular within fairly narrow parameters. What I predict is that if the legislation works that way, it'll just be ignored. In the same way that the law was ignored for 10 years, at least 10 years, 13 years actually, before the scheme decision in 2018. That is, you'll have a whole lot of people working in sectors like retail and hospitality who there was a plausible basis to engage them as a casual in the first place because it wasn't clear that they were going to be getting regular work. They're actually just being trialed, right? And then their jobs settle into being permanent, but nobody's going to argue that. And everyone's just going to say, let's just accept it. Employer's happy for it to be casual. The worker is not necessarily happy, but not thrilled with the idea of taking a pay cut. And then you have a conversion mechanism which hardly gets used. So I think we could have a reform to the law which addresses a small subset of the problem of permanent casuals, but the practical effect is to do very little. What would doing a bit more look like? So these are ideas I've put out before, so nothing really new here. My starting point is that we've got a problem that's not in the end a legal problem, it's a cultural problem. That we have employers and workers throughout Australia who just got used to the idea that casual employment is essentially a choice to be made where the worker gets a bit more money and doesn't get leave entitlements. They're not usually thinking about notice of termination or redundancy pay. It's really leave that they're thinking about. So it's a way of buying out leave entitlements. And the employer thinks they have an amazing degree of flexibility, which means that they have total managerial prerogative. Now, of course, legally, that's not true. You can still bring unfair dismissal claims. You can have long service leave, you get parental leave, you get family and domestic violence leave. But there's this perception there. So how do we shift those perceptions? How do we change the culture away from permanent casual employment? One way is to make permanent part-time employment a more viable alternative in those industries where awards genuinely don't offer the flexibility which employers might legitimately want to have. There's a room for a massive argument there, I will concede, about where that is or isn't true. But there's at least the need to have that conversation. Giving casuals more entitlements. I've previously said after 12 months, increasingly I'm thinking, you know what, especially after going through the pandemic, shouldn't casuals have paid sick leave right from the get-go? Even if it's maybe not the 10 days, maybe just 5 days. Maybe it's just paid pandemic leave, influenza leave. I think there's an argument for doing that. Making conversion the default option, so it's nothing to do with an employer decision. It's actually, you will be converted unless the employee elects to stay permanent. I actually think that's something the government might do. I'm not saying they will, I think they might. But above all, just accepting there is no quick fix to this, because this is a cultural issue as much as it is a legal issue. And I keep going back to those years and years in which I was giving talks and writing textbooks that say there's a problem here with casuals being entitled both to a casual loading and to leave, and nothing happening about that for the simple reason that it didn't suit anybody to raise the issue until suddenly it did in one industry. So we'll see what happens in this space, but I'm not confident that we're going to see a fix in this area which actually addresses the drivers of permanent casual employment in many industries And even if we do see successful action, I expect it to take years. Let me very, very quickly talk about the other issues, and I'll just quickly talk about what I think will happen. Labour hire regulation, well, government's talking about a national system. They're looking at a licensing system, not a registration system. The difference being a licensing system, there's a check on whether you're allowed to operate as a labour hire agency by reference to potentially both financial considerations and whether you're a fit and proper person according to your past conduct or the past conduct of anyone involved in prescribed ways with the organisation. The government is very much looking at a universal system. I'm still very much persuaded by the arguments that persuaded Anthony Forsyth when he did the labour hire inquiry for the Victorian government back in 2016, and the arguments that persuaded the Migrant Workers Task Force when they looked at this issue a year or so later, that there are particular industries in which this regulation is needed, not all industries. I think one of the problems here has been that one of the reasons why we ended up with much broader based state schemes was a desire to get at issues other than the kind of appalling forms of exploitation which were identified in particular industries, and most commonly horticulture, meat processing, cleaning. And in the end, an industrial agenda, which was really about other matters, transform what could and perhaps should have been a sector-specific regulatory response into a universal system. Right now, I would still say there's a really good argument for pulling a labour hire regulation, a national labour hire regulation system back to focus on particular sectors, or perhaps to have a national registration system which operates as a licensing system in problematic sectors, or which turns into a licensing sectors for registered providers who are shown to have misbehaved in various ways. The government is currently talking about the Fair Work Ombudsman being the regulator. That raises some pretty obvious red flags about the conflict between being, on the one hand, the licensing authority, and on the other hand, the body that's responsible for investigating and prosecuting contraventions of labour legislation, which are then relevant in making licensing decisions. It's not that it's impossible to see how that contradictional conflict can be resolved. But honestly, if it's not just a question of saving money, there really is a pretty strong argument, I would have thought, for having a dedicated regulator rather than giving it to the Ombudsman. The big issue, though, is how you define labour hire, and the government has really set itself a task here, because they've said, well, we don't want to just cover labour hire. We want to cover workforce contracting as well. That is where, rather than looking to an agency to send workers to come and work within an enterprise, you just basically contract out all of your needs for a particular type of labour that's then provided from outside the organisation. And the government gives cleaning as an example of that. But they then go on to say, but we, in the consultation paper, but we don't want to cover genuine subcontracting. And they talk about what happens in the construction industry with the, subcontracting of electrical work or plumbing or carpentry or whatever it might be. Good luck trying to draft a definition which captures workforce contracting but not genuine subcontracting, because I can't see that there really is a difference in the end. There is an answer at state level. It's in the Victorian Labour Hire Licensing Act. So the Victorian Act, and this is the best of the state or territory definitions from my perspective. The basic definition in section 7.1 of the Victorian Act is, in the course of conducting a business, the provider supplies one or more individuals to another person, a host, to perform work in and as part of a business or undertaking of the host. So that's a fairly tight definition of labour hire. It does not include contracting out, but there's a regulation, there's power to extend by regulation. And if you go and look at the regulation, it extends it to cleaners, fruit pickers, meat processing. In other words, the very type of sectors which were behind the original proposals for this legislation. To me, that's the right way to do it. It's to say we're covering labour hire, and then on a sector-specific basis, we're going to pick up some other things which, yes, might be labour hire or might not, but to avoid an argument about the operation of the main definition, we're going to pull these in. So that's certainly anyway what I'll be proposing to the government should be done.
I'm conscious that we are almost out of time,
I know.
or maybe over time, but I'm also conscious of the fact that the start time was very confused. So if you wouldn't mind wrapping it up shortly. And then, of course, for those in the room, please feel free to hang around and join us for a drink and something to eat. But otherwise, we might have to close it. Yeah.
Last 2 points very quickly. Same job pay. I did think about just putting the first slide up and leaving it at that. The first point up on the slide and leaving it at that. It's a lovely slogan, same job, same pay. Try defining it. I think we're going to see a fairly narrow version of the principle enshrined that'll basically cover the situation where you've got labour hire workers working alongside current directly employed workers who have an entitlement under some form of industrial instrument to a particular rate of pay, and then saying the labour hire workers should get that. If that's what it turns into, it's going to cover a narrow range of circumstances, but the very circumstances that prompted this commitment from Labor in the first place. It won't get into some of those awkward questions I've posed on the rest of the slide. I think, but we'll see. Employee-like workers. So there's a lot of uncertainty about this proposal, but again, it's clear what the genesis of this is. The Fair Work Commission is to be given a power to set minimum pay rates and to provide an accessible form of dispute resolution over unfair contract termination for certain types of self-employed workers. And it's very much been formulated with gig workers in the transport industry in mind. What's not clear is, well, there's certainly no indication that it's only going to apply in transport. I don't think there's any doubt about that. It's going to be drafted more broadly. The consultation paper does suggest that it could just apply to gig workers. Again, good luck trying to define what gig work is, because there are many different definitions. Even if you restrict it to work provided through digital platforms, that's really, really awkward. So I hope that the legislation will be a bit broader, but the big question I've got, and this is my main question, Tess is smiling as she hears me about to say, because she's heard me say this before. The big question, is this plan A or is it plan B? By which I mean, is it plan A for dealing with the High Court decisions last year that narrow the definition of employment in such a way that almost any type of worker is capable of being engaged as an independent contractor if you only draft your contract the right way? If this is plan A for dealing with that, in other words, if this is the only plan for dealing with it, then there's an argument for saying you make this as broad as possible and you allow the Fair Work Commission to declare any type of contractor to be an employee, because they ought to be an employee. The only reason they're not an employee is the High Court has adopted an absurdly narrow test. If, however, it's plan B, that is, if the government is going to draft a new definition of employment, and we've had no public indication that that is the case. It is certainly being talked about, but we've had no public indication from the government that there's going to be a definition. But if there's going to be a redefinition of employment that's going to address the issues the incredibly serious issues created by those High Court decisions, then this becomes not an afterthought, but it's a fallback for workers who are quite genuinely running their own businesses, but encounter problems with superior market power, such a way that they arguably deserve some sort of access to minimum conditions that bear some resemblance to what employees get. Those two propositions are completely different. And so my view about anything the government proposes here is, I want to know, are you doing something about the definition of employment? Because if you're not, then this has got to be, this really should be as broad as possible. But really you should. So that leads into the last slide. What's missing? The commitment to define employment. That's the big thing that's missing to me. Something else that the government hasn't talked about, but is going to be discussed this year because it is so firmly on the agenda of the Greens, bearing in mind that the Greens don't have the balance of power, but share the balance of power in the Senate. It's pretty clear from the work and care inquiry that Senator Barbara Pocock chaired, and can I say how nice it is to see someone with the academic credentials of Senator Pocock in a significant position in the Senate. It's pretty clear that the government, that the Greens are going to want action on what they call roster justice. So that is in particular dealing with issues of insecurity of hours, irregularity of hours, lack of notice of changes to shifts and so on. So it's that other form of work insecurity, which the Greens are going to want to see on the agenda. Are they going to get it? I don't know. They're certainly also going to want to talk about the right to disconnect. The idea that your security of hours means that you can leave your job and you are not going to be expected to be reading your emails or taking phone calls after working hours. Looking at issues of unreasonable or overpaid overtime, which are a huge issue in certain sectors. But then I want to go back just to finish with a couple of those commitments that you might or might not recall seeing on that graphic I put up from Anthony Albanese's tweet, which talked about government setting a lead in providing more secure jobs in the public sector. I'd be asking, what about more jobs in the public sector? What about re-examining the outsourcing that's happened over the years, which arguably has gone beyond sensible bounds in terms of policy outcomes? Is the government doing anything about creating more secure work in the public sector? I suspect there are things going on, and I suspect if they are going on, I probably don't know about them. All I would say is we're not hearing a lot about them. But promoting security of employment through procurement, which is another commitment. Again, if that's happening, I'm not aware of it, but stress, maybe it is going on and we're not seeing it. But there's an awful lot that government could be doing in those spaces to make jobs more secure. Are they going to do it? Well, some of the answers I suspect will emerge from the budgets that we're going to see tomorrow night and then next year. Not necessarily directly, but more in terms of what scope they give for a growing public sector that's able to offer more secure forms of work and that's able to set a lead for the private sector in doing that. And that's just part of the equation at the moment. I think it's fair to say we can't really judge the government because it is still too soon, but it's a space I'll be watching. Thanks for your indulgence, Tess.
No, thank you. Thank you so much for all of those insights, and thank you for the audience, both online and in person, for being so accommodating with the fluid start and finish times are very much appreciated, particularly on a Monday night. If you do have some time to hang around, please do so. We would love to chat because the centre hasn't been able to put on many in-person events of the past few years, and it's such a pleasure to host you here. So thanks again. Join me in thanking Andrew for his discussion tonight. Thank you.
Thank you.